Hi, everyone. I'm Kevin Johnson with the Illinois Fertilizer and Chemical Association. I appreciate you joining us today for this webinar on entry-level driving training. With my new role at IFCA after Gene retired, I started going on the road and starting to see more retailers. And there was a couple questions that usually got brought up, and one was the entry-level driving classing. How do retailers are going to be affected by this? And pretty much every stop I made, this question got brought up. So I thought it'd be a good opportunity for IFCA to engage membership and talk with Dan Myers with FMCSA and then Kevin House with the Secretary of State's office. These guys are on the front lines of trying to implement this training. So we're going to do just a webinar and try and get information out to our membership. This will be recorded and put on the IFCA website. So anybody, if other people in your company aren't be able to attend today, you will be able to pass this out. As always, if you have more questions after this webinar, please reach out to IFCA or KJ here. My email address is just kj@ifca.com, or you can reach me at 309-827-2774. Why don't we get right into the webinar? I'm going to turn everything over to Dan Myers with FMCSA for his slide presentation. I will tell everybody, if you have questions, please type them into the chat box or the question box, and we will try and get all those questions answered. Thank you, Dan, for joining us, and I will turn it over to you, Dan.
Thank you. I want to thank everyone for participating today on this topic, and we're just going to jump right into it. Can you see my screen now? Okay. Today, we're going to discuss the entry-level driver training rule, and we're going to give a little more background as we go into it. But today, we're going to talk about the rule, the training requirements. We're going to talk about the new training provider registry and what those requirements are for the training providers, as well as the driver requirements. And then we'll provide a little more information on the countdown as we prepare for February 7th of 2022, when the rule goes fully into effect. The final rule was published in 2016. The rule was mandated by Congress through the MAP 21 Reauthorization Act. That rule set the federal standard for mandatory training or entry-level drivers entering the industry. It set minimum requirements that the training providers must meet, and it's important to understand some states have requirements that exceed the federal standards, which Illinois does have, and we'll talk more about that here in a little bit. It also established the need for the training provider registry, and the compliance date is set at February 7th of 2022. The important thing to understand is this is a rule that the industry as a whole has requested for years. It's been advocated for, and through congressional act, we were required to set it forth and begin and set a path to do it. To give you a little bit of background in the rule development, this is one of the first rules we've done in a long time through a process called negotiated rulemaking. In the negotiated rulemaking process, we went into it with the idea of what the rule should be, and we brought interested parties in. And through those parties and through those meetings, we came up with a proposed rule, which is where we are today. We listened to the requirements of that group and the asks of that group, and as well as the comments from the public to get to the rule that we have today that you're going to see and hear more about as we go through the topic. The entry-level driver training rule is designed to improve safety on the roadside. It's going to ensure that everybody receiving a new CDL or CDL upgrade, or the school, passenger, or hazmat endorsement, are properly trained and have minimum training to meet that skill. It sets a baseline for that entry-level driver training. It identifies the standards that training providers must meet. It gives the states information they need at critical checkpoints in the driver's license issuance process, and further ensures that the drivers can operate commercial vehicles safely to meet their operational needs. Prior to the rule, anybody could go in, study for the test on their own, and get behind the wheel and go take the skills test and have no formal training. So this stops that and provides a path for some training for the driver to have beginning training to begin driving in the industry. What do the regulations require of the drivers? Well, first we need to understand who is covered under the rule. The rule, as seen on the screen there, establishes a new minimum training standard for all entry-level drivers, and it applies to those applying for a Class A or Class B CDL for the first time. It also applies to those who are upgrading from a Class B to a Class A CDL, or adding a hazardous material endorsement, a passenger endorsement, or school bus endorsement. As you may be aware, we have a Class C license that may have a school bus endorsement on, or a hazmat endorsement. If you're transporting, for example, blasting caps in the oil field industry, they'll typically use smaller vehicles that don't meet the Class A or Class B. So if you would have a Class C CDL with a hazmat endorsement, you would have to go through this for the Class A or Class B endorsement. So it's any combination of those that a person is doing for the first time, which is a key phrase. We'll talk more about that shortly. The compliance date of the rule is February 7th of 2022, and that's a date you want to keep in mind as you go forward. Any driver who has a CLP prior to the compliance date may obtain the CDL without completing the driver training. So if I go down to the Secretary of State's office and I take my written test for any of those required classes on February 6th of 2022, and they issue me a commercial learner's permit, a CLP, then I do not need to go through this training, as long as I go in and test for the CDL before that CLP expires. So that's an important distinguishment to understand. On February 7th, we only apply this rule to those who get the CLP or take the test on or after February 7th. If as noted there, if the CLP is obtained prior, or renewed CLP expires prior to obtaining the CDL, they would be subject to the requirements and have to go through this. So if I took my CLP exam, or took my exam on February 6th of 2022, and I failed to get a CDL within the requisite timeframes, or that CLP expired, now I'm jumping back in the process and have to go through it all. If a driver holds an SP or H endorsement prior to the compliance date, they're not going to be subject to the ELD requirements for those endorsements also. And that's important to understand. So if they had an H endorsement that expired, they could go through the H renewal process, and then they could get their CDL back with an H endorsement without having to go through this. Drivers who obtain a CLP on or after the compliance date are fully subject to the rules. And drivers who apply for an SP or H endorsement after the compliance date and have not had one before are subject to those ELD requirements for the compliance date. Entry-level drivers must complete the applicable training from a training provider who is registered with the Federal Motor Carrier Safety Administration. The training providers will be listed on our training provider registry website, which will be publicly listed in the fall of this year. Currently, the training provider registry is open. Training providers can begin registering in our system, which we'll talk more about here in a little bit, but nobody can see it yet, and it won't be publicly available till the fall. The training must be completed prior to taking the skills test, or if only applying for the H endorsement before taking the knowledge test. Whether or not a driver is subject to the entry-level driver training rules is determined by their commercial learner's permit and any pre-existing endorsements that they may have. So now we've talked about who's required. Let's talk about who's not required. The rule does not apply to anybody who had a comparable CDL prior to the ELT, entry-level driver training requirement. For example, I had a CDL before I moved to Illinois. I chose not to retest, and so my CDL has expired. If I elect to go back and get a CDL and go through the skills test, and the written test, I do not have to complete the entry-level driver training rule because I held a CDL prior. Now, if I'm going to upgrade and get a hazmat endorsement, then I would have to complete the training after February 7th of 2022. That's an important distinction to understand because that's another pool of drivers out there who do not need the training. Individuals who are not required to have a CDL per state waivers, as outlined in 383.3, individuals for whom the states have waived the skills tests, such as military waivers, which Illinois does participate in, they will issue CDLs to equivalent trained military personnel. Applicants who obtain the CLP before February 7th, so as long as they obtain a CDL before the CLP expires or the renewed CLP expires, or removing a restriction from the current CDL. So if I have a hazmat endorsement and want to let it go, I'm not subject to this. And reinstating a CDL after a period of disqualification also would not be subject to the ELDT. So what are the Drug and Alcohol Clearinghouse is subject to all commercial learners permits and CDL drivers who are subject to who are driving on public roads. Therefore, students who are enrolled in any of these training providers must be registered with the clearinghouse before driving on public roads with a negative result 30 days before the road training. If they're currently employed by a carrier, then the carrier will do the drug testing and the carrier will do the clearinghouse checks. If they're an independent student, meaning they're going to some training provider on their own, they must register in the clearinghouse as an employer, owner-operator basically, and a driver in order to perform the query required to meet the regulations in the clearinghouse. The important distinction from this slide is that the training providers are not considered employers. So the training providers do not have an obligation to run the student through the clearinghouse. They should just verify the student has complied with the regulations of the clearinghouse and taken care of themselves if they're not currently employed by a motor carrier. What are their training requirements? Well, entry-level drivers must receive training to demonstrate proficiency in two areas. The first area is theory. The theory training can include lectures, demonstrations, computer-based training, or online learning. It may include a simulator. The important distinction is there is no minimum number of hours. We only establish the curricula, the training topics of what must be covered. How many hours it takes to get to that training to make them proficient to obtain an 80% on an assessment test is up to the training provider and how long it's going to take. The second portion of this, which is separate, you can have two different trainers doing this. So you can have one trainer doing the theory and one doing the behind the wheel. Behind the wheel training is the actual operation of a CMV. It must take place on a range or public road. They may not use a simulator to meet the requirements of behind the wheel training. It must be actually behind the wheel of a commercial vehicle for this test or skills test they are wanting to take. Again, there's no minimum number of hours. It is the training provider's responsibility to determine that the driver applicant is proficient and can safely operate the vehicle. They must demonstrate basic vehicle control skills and mastery of basic maneuvers. The theory, as I stated, the theory and behind the wheel trainings may be delivered by different providers. However, both providers must be registered and listed in our training providers registry. Both training providers would separately submit their driver training information. Behind the wheel range and behind the wheel public road trainings must be provided by the same provider, however. So it's only the theory and the behind the wheel that can be separate. Once they sign up with a trainer and behind the wheel, it must be completed with that trainer. Driver trainees must complete both the theory and behind the wheel training within 1 year of each other for them to count. So if they take the theory and then don't get the behind the wheel within a year, they have to start back over and complete the behind the theory class again. Behind the wheel public road, the instructors must cover all topics listed and determine and document that each trainee has demonstrated proficiency in all of the elements in the curriculum unless otherwise noted. Our curriculum is found in Appendices A and B of Part 380 of 49 CFR. It does not allow for tests out of skills training on either the range or public road. They must complete the training. Now, in addition to our regulations, the state has regulations in entry-level driver training, although they've called it something different than what we do. And I will let Kevin talk about this and explain a little more detail on it. But in a nutshell, the simplest way to explain this is that the entry-level driver training federally will be for those CDL employers who wish to train their own drivers. I've got a trucking company. I want to establish my own training, and I want to conduct my own training. I'm not going to be subject to the state regulations. Conversely, if I decide to hang out a shingle and I want to do this for hire and I want to train other drivers, then I'm going to be subject to the JCAR regulations through the Secretary of State's office. This time I'll turn it over to Kevin to explain, and if you've got any questions on the differences between the federal and state requirements, we can take them now or you can hold them until the end. Kevin?
Thank you, Dan, and thank you, Kevin, for inviting me today. So, to get right into it, so there'll be two different ways we can do this as far as getting a CDL. You can either go through the entry-level driver training program that the feds have put out, or Illinois will still have their 160-hour driving school curriculum that we have. We will not change that. So you can pay to go through the driving school, come in and get your CDL, no problem, or you can go through the ELDT. The problem of where it gets a little hairy is this. So if you're a trucking company, Kevin Deuster Trucking Company, and I hire my people and I train my own people, that's totally fine under our state rules. Where it gets hairy is if it's Dan Meyer Trucking Company and Dan doesn't want to train his drivers, he wants to send them over to me because I have the curriculum and I take money from Dan, that turns into money, which turns me into a commercial school. So as long as the bottom line is this, as long as there's no money exchanged, it'll be okay to be trained by the other company. But once you get into the charging other companies to train their drivers, that's when it falls under our rules, which is the 160, and that's when you have to fall under the 160 hours of driver training school. So I don't know if that muddies the waters or not. Like I said, you can ask questions now or later, doesn't matter. As far as the facility part of it, once you've gone through the ELDT, it'll be seamless on the back end. You won't have to bring anything in. The provider will put that they passed, and it'll automatically go through our systems. We'll be linked into their system, so when they come in, it'll automatically go on the driving record when we're running the applications here at our facilities. So that part of it should be pretty seamless. We're working on that right now. We're doing all the programming for that, and we should be ready by February 7th of 2022. So, Dan, Kevin, I can put it back to you. If anybody has any questions, I can try as best I can to answer them.
Kevin and Dan, this is KJ. I would say most of our retailers are going to do their own training and not hire out. That's just my talking to a lot of them. So yeah, if you guys, as clear as you guys can be, if they're going to do their own training, we will just have to follow the federal rule. Correct if I'm correct in saying that?
Yes,
correct.
You are.
Okay.
Now,
that's one of the questions I get a lot on.
Okay, one thing along that line I do want to point out is if they're going to be doing their own training, one thing they may consider is they can piecemeal this out according to their needs. An example, if they want to go target current CDL drivers without a hazmat endorsement, they can build their own hazmat training course, which would be separate from this. And that hazmat training course is going to prepare those drivers to go down and take the knowledge test at the state driver's license facility, and then they can get the H endorsement when they comply with all of the regulations for a hazmat driver. So that's another option. You don't have to build an entire course. You can build with what you need. If you're only going to operate Class B vehicles with a hazmat, you can build a Class B curriculum. You don't need the Class A. So build it to what your company needs are. And that's the beauty of building as a company. You would be building to what you need. One example is I talked to an owner-operator that all they do is hire experienced CDL drivers. He won't hire a driver with less than 5 years, and he wanted to do his own hazmat training. That's allowable under this rule. So he's not going to need the Class A course. He's not going to need the Class B course. He's not going to need a road course. He's only going to need a hazmat course to get these drivers trained so that they can go take the test through the state. So the rule does allow for flexibility for those companies that are building their own curriculum.
Thanks, Dan, for that clarification.
Do we have any questions, Luis, before we move on?
Yes, we have a question from Josh Rund. Will FMCSA provide sample tests or a BTW check sheet and documentation? Or are these all things we should have to develop?
They're things you'll have to develop. All our rule does is give you the curricula that is required to be covered. We aren't going to give tests. We aren't going to give examples. It's the training provider has to establish their own training tests and their own methods. And one way to look at this is similar to what we went through with the medical registry rule. When doctors began to register for the medical registry, they had to go to a training provider who was trained on federal motor carrier safety regulations. We did not establish what that training requirement had to be. It was up to those training providers to establish what had to be covered and what had to be tested upon. And this is going to operate similar in that fashion. So all we do is say, these are the topics, these are the areas that must be covered. Once they're covered, it's the training provider's responsibility to develop the test and the testing protocol.
Dan, one other quick question for you. You did say in another talk, I think, if they have a trainer, if Kevin Johnson Fertilizer Company has a safety person on there and it's going to do the training, that trainer must have a CDL license. Correct me if I'm wrong.
You're correct, and we're going to cover that later on when we get into the trainers.
Okay.
So that's
Thank you.
on down the slide. Luis, I'll go ahead and move on. If we've got any more questions, we can cover them at the end.
Sounds good.
Okay, now we're going to talk about the training provider registry. The training provider registry is where the training providers are going to go to register themselves. And this can be a private company or it can be a training facility, either way. So if your local college has a training school, they're going to have to register in this just the same as ABC Trucking is going to train their own drivers. There's a process to go through. You're going to create a login.gov account. You're going to register, and you're going to register the locations of those. The training providers have to self-certify within here. We're going to talk more about the specifics, but they must retain a record of all drivers that have successfully completed the training. The important distinction is now the registry is available. We opened the registry up this month, and it is available where carriers can go in. But at the bottom are the key things. If you'll look down here at the bottom, you'll see we've got a link that goes into the curricula that it's required. We go into our requirements for facilities, but the facility requirements listed on our website are for those doing their own training only. Same thing with instructors. We talk about what the instructors need to do, what the instructor requirements are, such as they must possess a CDL. Down there, we talk about the state licensing requirements, and then we talk about the vehicles, what type of vehicles you must have to conduct the behind-the-wheel training. So the registry is a key place for you to begin gathering information after we conclude the training today. How does the registry support the entry-level driver training? Well, I, as a new driver, the first thing I'm going to do, it's after February 7, 2022, I want to get into the trucking industry. First thing I'm going to have to do, if I'm not with a motor carrier, is look for a training provider to provide the training for me. So I'm going to go into the training provider registry and look for a facility that I want to attend. And then once I do that, I'm going to submit, or I'm going to attend the training. And when I complete the training, then the training provider will electronically submit that data that I successfully passed into our registry. Our registry will be the central repository for that data, saying that Dan Meyer has taken the behind the wheel and theory training and has successfully passed on this date. Then when I go to the state driver's license office to get my CDL, Kevin's office is going to check the registry to verify that I have completed the training and I've successfully passed both the theory and behind the wheel training before I can take the skills test. Now, mind you, I would have taken the knowledge test for the core basic CDL and obtained a CLP before I began the driver training, but I can't do the skills test until I complete the entry-level driver training, except in the case of the hazmat endorsement. I must have the training before I can take the hazmat endorsement at the state. So if I'm going to add the HM endorsement, I'm going to have to go in there, and then Kevin's office would go in there and verify that I have successfully completed the hazmat training to allow me to sit for the test. The CDL applicant can search the list of providers on our registry. That will be released later this fall. That's why we're wanting training providers who intend to provide training to begin registering on our website. The applicant will then contact the training provider and secure the services outside of the registry. It's not done in our system. They contact them on their own and determine that they are willing to attend that location, or that school is willing to accept them to get their training. The training provider then submits the certification information to our agency electronically. The driver information must be submitted by midnight of the second business day after the driver trainee completes the training. And it must be done for each student when they complete that training program. And this falls into that behind the wheel theory, because I cannot take the behind the wheel until I've completed the theory. Now, if I'm going to the same location, they still need to enter that theory within the time by midnight of the second business day, so it's in there. They can't wait until I totally complete the course. They need to complete that, because if I elect to leave that behind the wheel and go somewhere else, I need that documentation that I've already completed the theory training portion. So they're still required, even though I'm staying there, to enter it by that second business day. And then when I complete the behind the wheel, they will enter that information. Then I can go to the state and I can take my skills test, and they're going to see both dates in there. I should not see both dates being the same for the theory and behind the wheel. That should not occur. If that is, there's a problem somewhere that needs to be investigated. Again, our registry will be the database for this. It will be secured, and this is where all of the information will be retained on their entry-level driver training that any driver or driver applicant has taken. And again, as I stated, the state, prior to administering the skills test, must use the information in the registry to verify that the driver has completed the required training and is eligible to take the skills test. And the states can only accept, we will only enter information from people trained in our, or identified in our registry, and the states will only get that information if they've successfully registered and completed that within our systems. What are the regulations required of the training providers? Well, first of all, we need to answer, who is a training provider? Well, a training provider can be a school, educational institution, rural electric cooperative, motor carrier, state and local governments. We're going to have a lot of those. We're going to have a lot of school districts out there that are training their own. We can have labor management programs, owner-operators, individuals. So just about anybody you imagine can become a training provider if they meet the regulations and are willing to comply with the regulations. What are those regulations? Well, they must register. They must establish a curricula that meets the requirements of the federal regulations. They must have qualified instructors pursuant to the rule. They must have facilities that comply with the rule. They must have vehicles that comply with the rule. They must ensure that state licensing is followed if required. And then they must provide assessments of those drivers for both the theory and behind the wheel. and then they provide the training certification, the documentation, and most importantly, they must agree to be soaked at regular FMCSA audits from our agency. For the full requirements, you can go into 49 CFR Part 380, subparts F and G, is where you'll find all of this information that we're talking about here. Registering, in order to be authorized, they must register with our agency. Again, registration period is currently open. During the registration, the providers must self-certify that they meet all applicable state and federal regulations. Only registered providers will be listed on our registry, and again, that will be publicly available late this year. Beginning February 7th of 2022, they will begin submitting certifications. So should a school start up in November and a student say, I need the training anyway, even though it's not required, and I complete the training in December, the training provider would not enter the information at all because it's not applicable. It will be only those who have completed the training after February 7th that needed to have it before they'll put it in. Training providers are required to register even if they don't provide training to the general public. This is the information I talked about, like motor carriers. If you want to set up your own training and you want to train your own drivers, you still have to register with this. However, you can go in there and say, do not list our information publicly, and you will not be contacted by the public. But you must be registered and must be willing to comply with the federal regulations. The curriculum must include all topics covered in 49 CFR 380, appendices A through E. But again, there is no minimum number of instruction hours. Separate providers may provide the theory and behind-the-wheel portions, but both portions of the behind-the-wheel training must be provided by the same driver, and that would be your range and road training. So that's the two behind-the-wheel trainings. Your driver trainees must complete both the theory and behind-the-wheel portions of training within 1 year of each other, the only exception being those people wanting the hazmat endorsement only. The driving simulator can be used for theory only, cannot be used for behind the wheel. Remember that. You can download our entire curricula. There's a summary on our website, which is a link in the PowerPoint that I'm going to have available for you guys to review later. Or you can go to our website and review it. To instructors. For instructors, for theory and behind the wheel, must hold a CDL of the same or higher class with all of the endorsements necessary to operate a CMV for which the training is provided. They must have at least 2 years of experience driving a commercial motor vehicle requiring a CDL of the same or higher class and or with the same endorsements. Or they must have at least 2 years of experience as a behind-the-wheel CMV instructor. If a instructor's CDL has been canceled, suspended, or revoked due to offenses identified in 383.51, such as too many speeding tickets, DUIs, reckless driving, the instructor is prohibited from teaching for 2 years following the date their CDL is reinstated. So in the case of a DUI, if an instructor were to unfortunately get a DUI in their personal vehicle or commercial, their CDL is going to be revoked for a year. And so they would have to wait that year revocation, get their CDL reestablished, and then get 2 years more before they could become an instructor again. So you can see there are serious consequences for instructors. It's important to understand that your instructors must be trained and must have the same endorsements. So in the case of your organization, I anticipate most drivers are going to have a minimum of a Class B CDL with an H endorsement. And they must have that for at least 2 years prior to beginning instructing. It's an important distinction for you. More information can be found in 380, Part 380, and 389.605, where all of this is covered. Our facilities are explained in the regulation. The classroom and range facilities must comply with all applicable regulations, federal, state, or local regulations. The range Has to be an area free of obstruction, have adequate sight lines, and must enable the driver to maneuver the vehicle safely and free from interference from other vehicles and hazards. So, for example, range can't have public access. You can't have the public driving through your area. So Walmart parking lot on Sunday afternoon is not an acceptable range. That's how I think of it that way, because the public can access it. They can't be in there if you're going to be doing that. Training providers may conduct behind-the-wheel training in any area that meets the 3 requirements above. They are not required to rent or maintain a private facility or space. The range training, if it is conducted in a public accessible area, all the CLP requirements also apply. The vehicles must comply with all applicable federal and state safety requirements, so must be properly inspected and must be a safe vehicle to be allowed on the road. And believe it or not, this is actually an issue of concern. Prior to this rule, when I was in my other state, I was contacted by several people who were attending a driver training school, and the vehicles could not even pass the basic federal inspection requirements. And so that became a problem that we had to go in and investigate and take care of. So as silly as it sounds that they must comply, that is an issue. The vehicles also must be the same group and type in which the driver trainee is intending to operate for their CDL skills test. So if you're getting a Class A with a 5th wheel, you must use a Class A vehicle with a 5th wheel. You can't use a Class A vehicle with a pedal hook. So it's got to be with what they're going to drive. If they're getting air brakes, it's got to be a vehicle equipped with air brakes. So keep that in mind. You must match with what they're trying to get their tests in. Training providers must also be licensed, certified, and registered by the state where the training is conducted, if applicable. Again, Illinois does have instructor requirements at certain levels, so it's important to understand that distinguishment. If a training provider is offering theory only online, then the state licensing requirements may not apply. Again, it comes down to whether the state requirements apply or not. Theory assessments. The training providers must use assessments, written or electronic format, to determine proficiency in the curriculum. Students must earn a minimum overall score on the test of 80% to establish that proficiency. The training, the instructors must evaluate, behind the wheel training, the instructors must evaluate and document a trainee's proficiency in those skills. Training instructors must document the total number of clock hours each trainee spends behind the wheel curriculum to become successfully proficient. Again, there is no minimum. Now, an important thing to understand is one of the things that will be monitored is what your students do once they leave your facility. What is their pass-fail rate when they go to the state? If we're having a high percentage of the students failing, not only are people going to quit going to you, but it could impact that we may need to come in and visit and talk about your reports. So keep that in mind. You want to, just for your own edification, you might be in best interest to track how your students do once they go test. If you're doing your own, you're going to have a core knowledge of how they're doing anyway. The driver training certification, again, the information must be submitted to the registry by midnight of the second business day for each of those training courses. The information submitted must include the driver's trainee's name, date of birth, license or permit number, and state of issuance. The CDL class endorsement for which they are trained, and the specifics about the type of training, for example, theory or behind the wheel, the score on their theory assessment, and the total number of clock hours spent behind the wheels, and the date of the completion of the applicable training, whichever training was. Again, you do not upload or submit the information until after February 7th of 2022. Documentation record retention is a requirement of the regulations. All training providers must retain specific records, including the self-certifications accepted by the driver trainees for the behind-the-wheel training, attesting they comply with the regulations. A copy of their CLP or CDL. Instructor qualification documentation is going to be a critical point. We must have that. We must have the documented 2 years. Lessons planned for the theory and or the behind the wheel, range and public road training curriculum must be available, and you must have records of individual driver training assessments, and all of these records must be maintained for at least 3 years. Now, in the case of an instructor, to get the 2 years, you may have to go a little longer than 3 years. It's possible you may have to go longer in some examples, but it's a minimum of 3 years, which the required record is generated or received, except in the case of a behind-the-wheel instructor CDL who has been expired or been canceled, in which case you would have to start all over with them and reestablish their time. Audits, as we talked about, the training providers must agree to allow FMCSA or its authorized representative to audit their operations. If our agency determines a provider does not meet the requirements, we may remove them from the registry. Any training conducted after the provider's removal date will be considered invalid. Training providers who wish to remain listed on the registry may appeal the decision or take corrective action. One thing to keep in mind is you must keep your information in the registry current and valid. If there is any changes to your information listed within the registry, such as mailing address or physical location address, you must change that information in the system within 30 days, but at minimum, you must update your listing every other year, even if nothing changes. So it's just like a motor carrier. You must do the biennial update, even if nothing changes. We have to know that you went in and verified that, yes, everything is current. Again, maintaining registration within 30 days. If there's any changes to the type of information, if there's a change in your state licensing or certification or accreditation, that must be in there. And then again, you have to do it at least every 2 years. FMCSA may remove a provider from the registry if they fail to comply with the requirements, if they deny us access during an audit or investigation, if we discover material deficiencies in the program, operations, or eligibility, or if they falsely claim eligibility to provide training, or based upon the evaluation of the pass-fail rates for students or the providers based upon state testing scores. Removal again means that training conducted after the removal date is invalid, but on a case-by-case basis, we may retroactively invalidate any previous training if the driver trainee is willingly engaged in fraud or other criminal behavior. How does a provider get ready to submit their information? Well, there's going to be two processes for training providers to submit. You can submit manually, which is probably what the majority of people on this call is going to want to do. Because a manual submission is you just go in, you enter the information on the driver using an online form. The web services submission is an optional process, but it's typically going to be your very large providers who are entering a lot of information. That involves setting up your own IT system with a web interface to submit data dumps on a daily basis to the web service. So that's a costly enterprise. Most people aren't going to do that. I envision most of the people on this call are going to use the manual submission process through our website. The web service option is a good fit if you've got large numbers. Again, you must have existing IT systems that track, and you must go through the process to develop it. If you fall into that category that you're going to build that large, there is information on our website with a developer toolkit that you can go to understand that process. Resources and support are available to providers to identify how to build your own training. It's available at our website. Our website for all of this is TRP, which is Training Provider Registry.fmcsa.dot.gov. Once on that website, we've got links to everything. One of the links we talked about is the developer toolkit. It's there. You can get testing support, and you can get access to the registry developers or ask questions or ask for troubleshooting information. But the main website, trp.fmcsa.dot.gov, is where you're going to find the majority of the information you need after today's webinar. Of course, we're here if you need help. You can contact the organization or you can contact myself. If you want to become a training provider, you need to get ready to register. You need to ensure you have a curricula that meets the regulations. You've got the documentation on your instructors and your vehicles that meet the minimum standards. When you register, you must self-certify that you do comply with all of the regulations. So don't register until you've built your training curricula if you don't have it established already. Again, all of the training provider requirements are listed in 49 CFR Part 380, subparts F and G, and appendices A through E. So you can find out more information and actually read the regulations yourself. Now we're in the process of getting ready to count down for full implementation. Right now, in the summer of 2021, the training provider registry begins. The website's open and available for training providers to begin registering. This fall, we will make that list of training providers publicly available on their training provider registry website. And then February 7th of 2022 is the compliance date, where training providers will begin submitting training certification. States will begin verifying driver training and certification information. Now, the key information here is, when did they get their CLP? When did they take their learner's permit test? So if you have a driver who takes the test on February 6th of 2022, as I stated, they are not subject to this rule, do not need to complete the training. Or if they had a CDL prior to that with the applicable endorsements needed. So keep that in mind as you go forward. Again, all of the information we've talked about today is available on our website. You can sign up for email updates from FMCSA, and I highly encourage you to do that. I sign up and I get notified on a regular basis when there's any changes to the website. I was notified when the registry opened, the day it opened. I'm notified when there are changes, when there's additional things added to the website. You can find answers to frequently asked questions. The questions can be from the driver perspective, from the trainer perspective, or from the state perspective. And you can access developer materials to help you build a web service if needed. There's a fact sheet for drivers and an overview presentation that won't be as detailed as this one, but there is an overview presentation on our website. And then providers, there's a fact sheet, a countdown checklist, and then a curricula summary that you can use to help build your curricula and make sure it is in compliance with the federal regulations. Any questions?
Yes, we've got a few here. We'll go through them. Our first question is from Cameron Minaret. How are temporary 90-day seasonal CDL drivers impacted? Do they need to get trained each year when applying for the temporary CDL?
Well, no, they're not going to need to do it each year if they're returning, because as we talked about, if you've had a CDL prior, you're not subject. So like me, I can go back and retest it at any time. But they will need it prior to getting it for the first time.
Okay. We have another question from Greg Price. If we choose to provide our own training, will we be open to any liability should that driver move into another company?
As long as you follow the federal regulations and your training is compliant with the federal regulations, first of all, I'm not an attorney. Anybody can be sued for anything at any time. However, if you have complied with the federal regulations, there should be you follow the standards, and you should have that ability to fall back on that you did what the regulations required of you. But again, I'm not an attorney, and I cannot speak into the legal aspects of it.
All right. We have another question that was answered, but I think it's good to go ahead and ask it for the group. If I have a Class B CDL with hazmat, can I do theory training only for someone wanting a Class A? The behind the wheel would then be done by a Class A instructor?
There is a separate process in the curricula for going from a Class B to a Class A. We did modify the rule after it was initially issued to allow for a different training course, because when the rule was originally issued, if you had a Class B, you had to retake the entire Class A course. Now it allows for a different course to be taken because Class A or Class B, you've already got the core knowledge of that, so you shouldn't need the theory, but you will need the behind the wheel. So with that Class B transitioning, you can then go in and take the behind the wheel training from a provider. So you will need that at least before you can go take the skills test.
All right. And our final question comes from Lacey Burke. How long should a driver wait to go to the DMV to test after training provider manually submits their certification?
Once the training provider submits the certification, they're eligible to go at any time. I would suggest they get on the Secretary of State's website and register, because there can be a waiting period. You can't just walk in and take a skills test in a commercial vehicle. So you have to register with the state. Kevin can talk more about that, but the minute it's in the website, you can go ahead and register. And drivers will be able to see their own information, so they can verify that the information has been entered on their behalf, so they're now eligible to take the skills test.
All right. Thank you, Dan. That completes our questions that are submitted.
Hey, Dan, real quick, and I think we're okay with everything, but you're okay with us providing the slides that you have to our website and to our membership, correct?
Correct. I'll go through, I'll submit you a PDF copy of the slides as soon as we get done. I'll email that out to you this morning, and you can post it on your website.
Thank you, Dan. And like I said, that's why I know I've already had a couple text messages about that, if that will be provided. So appreciate that.
Yes.
If there is any other questions for Dan, we'll go right into Kevin with Secretary of State's office. Kevin, take it away.
Okay, well, again, I appreciate you guys having me on today. Most of what I spoke about earlier is kind of about what we do. I just wanted to clear up a couple of things. So I gave the example of me having a trucking company and Dan having a trucking company. So if I'm training my own people and they're for hire and everything, I fall under the ELDT, the federal FMCSA rules. So if Dan starts bringing his people over to me and I start charging Dan for his people, that puts me into the Illinois state law, which you have to follow our state laws as far as the 160 hours of training. So I wanted to kind of explain that earlier. I just wanted to make sure everybody understood that. So anytime any money's exchanged or anything, you turn into a commercial school, you have to follow our state laws, which is what Dan kind of went over, of our 160 hours training, which is Franklin Adams up in Elk Grove. He works for the drivers for me, and that falls under his shop. But like I said, everything should be seamless once this goes on. You don't have to bring anything into our facilities. You can just come into one of our CDL facilities. Everything should be on the back end, on the programming, the computer side of it. We'll run the DL number, and it should come up. If there is any issues or any problem at the time, we will, if it's not on the registry for some reason or we're not retrieving it, we won't be able to give it to the driver per the federal rules. So we won't have a number per se as far as, you can call our CDL hotline if you're having any issues. I really don't want to get to the point where we're giving our CDL hotline number out just to check statuses on their their entry level driver training. So you really need to go to your whoever's doing it, your provider, and make sure they've loaded everything onto our systems. And Dan's right. As soon as you've done everything and you've gone through the ELDT and you want to make an appointment for the CDL pre-trip skills and road, you can call the CDL scheduler, which is 217-785-3013, or you can do it online and go to our website, www.cyberdriveillinois.com, and go to CDL schedule, and you can schedule online and that's anytime, day or night, you can do that. Other than that, that's about all I have as far as ELDT. If there's any questions for me, I can take them right now, Kevin.
We had one more question come in. I'm not exactly sure who is going to be able to answer this one. With the limited amount of miles that we in the ag business drive, Is there any possibility there may still be an ag exemption to this?
No, because the problem is, once I have a CDL, I'm released in the motor carrier industry. There's no exception that says this is only an ag industry related CDL. So the issue is, once you go through this, you are eligible to drive any CDL vehicle. So therefore, you must comply with the regulations. This applies to school districts. It applies to governments. It applies to anybody who's obtaining a CDL.
All right.
Go ahead, Luis.
No, that's our last. That would be our last question that's come in.
Hey, can I ask a question? And Dan, I think I'm going to ask it to you. So the other MAP 21 rule that you guys have is the J51, which is a state distinction we have, which is a non-CDLA. They won't have to be covered under that, correct?
Correct. Your J51 requirements are unchanged. This rule does not impact those. Because
it's a non-CDL.
CDL. Right.
Right. Okay. Just want to make that clear because there's some farmers out there that are asking that. So.
No, this has no impact whatsoever on the J51s.
Okay.
Kevin, I think you kind of answered this, but just want to make sure. Two questions to the Secretary of State's office. One, what will you have to provide if it's February 10th? What do you, documentation wise, stuff like that, what would you have to bring in to Secretary of State's office? Do you need to bring anything? But I think you kind of answered that, but kind of go over that again.
Yeah, they won't have to bring anything because it'll have to hit our registry. They could bring in a completion thing, but that doesn't matter until our systems hits the registry to make sure it loads on there. So, and we'll be going off the FMCSA's registry on the back end on our program. So really, they don't have to bring anything in besides their driver's license. So no, they don't have to bring any documentation as far as a completion form or anything like that. It'll all be hit on the back end on the program through the FMCSA registration.
The other question I get, and it's kind of to both of you. One, do you guys see any extension? I always get that to going past February 7th. And if there's not, do you see, Kevin, any hiccups through the Secretary of State where this stuff wouldn't be online or you guys wouldn't have the information? Those are the two questions I always get, is about extension, and then at Secretary of State, that is pretty seamless. And I know we haven't got to that, but give me your thoughts.
Oh, number one, as far as we see it, Dan will have to answer that as far as pushing the date back. We won't have any say in that. Number two, we'll always have programming issues and stuff. I'm just going to be completely honest with you. I mean, we'll be ready by February 7th. Will we have delays here or there once in a blue moon? Yeah, we will. But I think we'll test it really hard before we put it out. So we'll actually start testing, let's see, February 7th. We'll actually start testing right after the New Year. So January 2nd, when we come back to work, we'll start testing for that whole month to make sure everything's right. And we actually bring testers in from all over the state, and they come here to Springfield. We actually have a testing division downtown at the Howlett, and that's all they do for 8-10 hours a day is test this. Any way we can try to break the system, we do. So as far as the programming side on us and them, we should be ready to go, no issues. But like I said, there's always issues programming wise, no matter what you do, you know that, as far as computers. So, and I don't know anything. I always say this, but I know nothing about IT besides how to spell it. So I'm not a computer guy. So, but we'll be ready by February 7th.
Thanks, Kevin.
In relationship to any extensions beyond February 7th, I would not anticipate that. This rule was already extended 2 years. The rule was designed to have been implemented in 2020 based on its publication dates. The extension was done for IT services because states could not be ready. We have a path set forward for it to be ready. When we proposed this extension to the 2022 date, industry fought back on that. Industry was very upset as a whole. So I would not anticipate or count on any extensions to be coming.
And I appreciate that. We just get the question all the time. So
Understand.
Louise, do we got any other questions out there?
We do. One more came in from Clayton Drost. Can you talk about the temporary ag CDL that is specific to the retail ag industry? They are not allowed in the general trucking industry. Does this apply to that type of CDL?
Like Kevin, I presume they're talking about the J51. Is that what he's talking about, Kevin?
I would think that's what they are, not unless they're talking about the 90-day.
I actually think they are talking about the 90-day. I'm wrong, but all our ag retailers use the restricted B license, the temporary 90 days. If they hire somebody to pull ammonia tanks for that short window, I think it is that what they're actually asking about.
Yeah, once it's on there.
I'll be wrong. If I'm wrong, I misspoke, but that's where a lot of our ag retailers use the 90-day one.
So once they go through the training, the first time they won't, like Dan said, we weren't on the assumption they had to keep doing it. So once it's in there, it's in there. So we'll get that off the program every time they come in to renew that. So no, that won't change. They'll still have to go through the same process as far as the application process with us, but they'll only have to do it one time. So grandfathered wise, Dan, I guess we'll grandfather them in, correct? I guess that might be the ultimate question.
If I'll have to go back and I'll get you an email confirming, Kevin, but the way it's explained is if you had a CDL before, the same class, you do not need to complete the training for it to reestablish. As the example I gave, I had a Class A. I'd let it go when I moved to Illinois. I can go back, take the skills test, and require testing, but I do not need the training because I had a Class A CDL before, and the record will indicate it. Because once you have a CDL, you have what's called a CDL pointer within the driver's license systems. My CDL pointer is still hanging out there. It's inactive, shows me eligible to obtain a CDL, but it's still out there. So because I already had that pointer, I'm not going to have to reestablish. Pointer's behind the scenes technology term, but the key thing is I had a CDL. I would not have to go through it again.
So yeah, because what'll happen is, so see, our program will pull it off, your program. So we'll probably have to, when they apply for it into the CDL area upstairs here, we'll have to maybe load that on there to the record. We'll have to wait to load that on there to the record, because that way when they go to the facility, there's no issues or anything. So yeah, if you can get me something on that, I'd be appreciated. And as far as the J51 or the J50, if that's what the question was too, I'll hit both of them. You won't have to do any training, the entry-level driver training for that. That'll just be what it is today. I think it's $30, and you'll have to take all the applicable knowledge tests here in the facility. So you will have to go to a CDL facility to do that, and then you'll have to schedule an appointment for pre-trip skills and road, but you will not have to go through the entry-level driver training for either the J50 or the J51, which is a non-CDL status license.
Let me clarify. Clayton was kind of typing in there quick while you guys were talking, and I apologize if all this was already covered. He first wanted to clarify it's 180 days, but he's never heard of the J51. I don't know if that means.
So the J51 is a farm exemption. It was in the MAP 21, I believe in 18 or 19, Dan. So that what the J51 does is it's for the farmer's family and any employees that work for the farmer, and it's an exemption for them, and they can drive anywhere in the state of Illinois. It has to be for farm use, and of course the truck and the trailer has to be farm plated. But it's a regular CDL written test and a regular pre-trip skills and road. They just don't have to go through the drug and alcohol or the medical process, and it's a $30 fee, I think, for us. So the J51 is a farm exemption that the feds on the MAP 21 early on put out. So nothing really to do with your retail area. The only reason I really brought that up earlier is because I assume a lot of your retail workers are farmers on the side also. So I just wanted to let them know that the J51 wouldn't cover them you wouldn't have to have the entry-level driver training for that. But if you're going to go work for the industry, like KJ was saying, then they would have to, and get a CDL, they would have to go through the entry-level driver training then. So just wanted to kind of throw that out there early. Didn't mean to muddy the waters for anybody.
All right. Next, let's see. Class B only. Again, we may have covered this. He mentioned Class B only for the 1,000 gallons of diesel or less and 3,000 or less of ammonia. And that was a few minutes ago when you guys were discussing pretty quickly there. So that may have been answered. Let's move on to the next part. These are temporary and seldom show on an MVR. How would they ever know if they had it previously?
Again, that goes back to the record. Like me, if you run my driver's license today, it's not going to show a CDL. But behind the scenes, there's a thing called CDL eligibility that only shows in the CDL data. And that's where you can tell that within that system, we can tell that I've had a CDL before. The fact that a driver's had a CDL does not go away. It's retained in the system, and we've got that information.
And then finally, he wrote, yeah, this isn't a J51. This was specific to ag retailer, but I think we covered that.
Yeah.
And then finally, Kelly Maynard, I hope I pronounced that right. Apologies if I didn't. If an employee had a restricted CDL prior, can they get a Class B CDL without ELDT?
Repeat that again, if they had a what prior?
If an employee had a restricted CDL prior, can they get a Class B CDL without ELDT?
Well, now that depends what the restriction was. If they're restricted, for example, if you've got a restriction that says you can't drive a fifth wheel, well, it doesn't apply to Class B, but if you've got a restriction that says you can't drive an air brake vehicle, you still can't drive an air brake vehicle because you've not been trained. So it's all dependent on what the restriction, when they say restricted.
Right. Well, okay, they're coming in a little bit more. Kelly was referring to the farm-related services restricted CDL.
A farm driver's license is the J51 issue. That's what she's talking about.
Okay. I'll give her another second. We'll give her another second to see if that answered her question.
Okay.
But that wraps up the questions that have come in so far.
Okay.
Well, first of all, I want to thank you guys for taking the time, because we're get a lot of questions about this subject and trying to answer. And I know there's probably going to be more questions after this, and I'll try and if any of our members have more questions, please email me at kj@iefca.com, and I'll try and at least ask Dan or Kevin and try and get answers back to you guys on this. But I know we went over an hour, so I don't want to take too much more of their time. We've taken a lot, but I appreciate you guys just taking the time. Is there any last questions that we have out there real quick, Louise?
Nope, that sums it up. Oh, yeah, I'm sorry. They're coming in quick. This is Kelly again, reiterating what she's, or clarifying what she's saying. This is the 90 to 180 day Class B non-CDL that the farm industry uses for fertilizer hauling. Is this a quote CDL end quote in the state's eye?
I'm going to have to do some research and get back to you on that.
Okay.
And we'll post any of those questions back. We'll get back to you guys on that.
Yeah, I don't think there's such a thing as a 90-day non-CDL. I thought it was a restrictive CDL for the 90 days.
It is,
so
Kevin.
So if that's the case, they will have to it'll go back to what, Dan said he'd look into it, whether we have to whether we can go back and they don't have to go through the training since they've had it before. I think that's what she's trying to get at. So we'll have to have Dan look into that and get back with us. But as far as anytime you deal with so just to make it simplified, I don't mean to sound condescending here, but just to simplify the whole thing, if it has anything to do with a non-CDL license, none of this applies. None of this ELDT applies.
I think what we get at, we hire a lot of, we use the restricted B ag license, it's a 90 days, and they might come back every year. So I might hire Kevin Johnson retail, I might hire Dan every spring and fall, but he's already taken it. I think it would be exempt, but I'll go back to Dan, we'll research this more, that if since he's taken it already, he doesn't have to retake it because he's coming back every year, but he's already taken that test and the skills.
Correct.
But we will get back with you, Kelly, and get those answers to you guys.
Kelly, if you can please email Dan Meyer, his email is up on the screen, dan.meyer@dot.gov. Please get in contact with he and KJ, and let's get that communication going, please.
And I will make sure Kevin's copied on any response I give if you're not.
Again, I just appreciate Dan and Kevin and Louise for setting this up. If we get more questions, if we need to do another webinar when we get closer to it, we probably will do something. And I will probably ask Dan and Kevin to come speak at our convention in Peoria when we get closer to the February 7th effective date to see if there's any other changes. But I appreciate the time. Last thing, you want to go to the last slide, Louise?
Yes,
I just
sir.
want to remind everybody, the 40th anniversary of the Maggie Show is coming up August 25th and 26th. Pre-registration is open as we speak at ifca.com. So there is a discount if you register now. We look forward to seeing everybody the fourth week of August here in Bloomington at the Maggie Show. We're going to throw a big event again this year. So I appreciate the time again for everybody. Thanks for just getting on the call, and we will see everybody next time. Thank you, guys.
Thank you.